Good afternoon, everyone. Honorable Sir, Dr. Bhasin, Pratibha, Mamta, and my dear friends. It's an honor and a pleasure to actually talk about the future of dispute resolution. We have heard the first panel. They spoke about the Arbitration Act and how to make it work. We spoke about institutional arbitration. We spoke about the challenges of ad hoc arbitration. We spoke about the third party funding, and we spoke about the challenges of cross examination and the lengthy evidence that we have in place. Sir also touched upon some very interesting aspects. In fact, when somebody senior to you and somebody senior as Dr. Bhasin speaks, there's very little that is left for people like me to talk thereafter. So I would only take the cues from you, sir. You spoke about what is inherent in our culture, what is inherent in our history, and what is inherent in our heritage. So I just wanted to understand from you, how many of you have heard about Chanakya? Anybody? Some of us? Some of us have. Everybody has. So Chanakya had spoken about Chanakya Niti. He wrote a book called Arth Shastra. That book, Arth Shastra, actually is a compendium of various kinds of issues that have been covered. One very interesting key issue that has been covered is also about dispute resolution. He had authored this book around 2300 years ago, and it is still a beacon of strategic acumen. The lessons that can be learned by the rulers and the statesmen is in the art of governance and conflict resolution. It stands as a testament to the sophistication of our ancient Indian civilization in governance and statecraft. And it is primarily known for its insights into economics and political science. It touches upon a very interesting term, Sam, Dam, Dand, Bhed. What is Sam, Dam, Dand, Bhed? Sam is conciliation, Dam is incentives, Dand is punitive measures, and Bhed is strategic division. This was one of the key and nuanced approach that was given at that point of time, 2300 years back, by Chanakya to us. The other lesson that we can learn from history is from Ashoka. After the war of Kalinga, when he realized that this bloodshed is not taking us anywhere, he gave up everything and brought about peace within himself. The third lesson that we can actually learn is from Confucius, who had taught us the relevance and importance of harmony and virtue in interpersonal relationships, advocating for mutual respect and understanding as the cornerstone of societal cohesion. When we talk about mediation in today's time, I think the basic principle of mediation in today's time is precisely this. So when we learn all of these lessons from our history and bring it to the modern times, we have a lot to change. We have a lot to transform. Sir has mentioned about how the alternate dispute resolution has definitely failed. I think the term alternate dispute resolution has to change now. It has to be called appropriate dispute resolution. Because appropriately, we will have to find which of these mechanisms work best for what kind of dispute. So if we look at appropriate dispute resolution, and I think it is in this context that we can talk about mediation. Mediation has been at the core of our principles and practices. Sir spoke about from the Mughal times and even before. I think panchayat system and I think the basic essence of our evolution of the Indian system, legal system, has been the mediation. But why was mediation? Mediation has always been there. Why was mediation not able to be successful? Till last year, we did not have a codified act on mediation. So it was on a best efforts basis. We used to enter into settlements, but how many of those settlement agreements were actually capable of being enforced? So what has really changed for us now after the Mediation Act has come is that it has given a sanctity to the process. You can now seek an enforcement of that mediation agreement that is entered into. So you are able to resolve the dispute outside of the court, It is much less expensive as a process, and you are able to give teeth to the whole process of settlement. So I think that's one very important element that has changed. When we talk about the future of dispute resolution, I think we cannot do without touching upon the most important element, that is technology. Ishna, I think, was mentioning about, smaller disputes. I think for the smaller disputes, the evolution of the online dispute resolution mechanism has really played a very important role. So ODR is becoming more and more common, especially in small claims and cross-border disputes. It allows the parties to resolve disputes without needing to be physically present. It leverages the digital platform for communication, negotiation, and even for arbitrations. The other element which is likely to change the entire game is the artificial intelligence. Now, this introduction of artificial intelligence in ODR platforms are becoming more efficient, potentially using AI to mediate certain disputes or assess the strengths and weaknesses of a certain case makes it even more relevant and more contextual. And the integration of digital technologies into ADR has led to the development of the ODR platforms. The ODR platforms are extending the principles of ADR into the digital realm and offers tools that allow for the resolution of disputes arising from online activities. So I think the introduction of AI both in arbitration as well as in mediation is definitely going to be the game changer for us in future. It is going to make it lower, in terms of cost, lower cost, because digital platforms and AI driven solutions can, and it is a potential that we see, potentially bring down or lower the cost of dispute resolution, and it will make it more accessible to the individuals in that sense and for the businesses of all sizes as well. The other very important aspect that I think is going to make change, and we did discuss about it last time, was about the early neutral evaluation. In fact, one of the law firms is taking this initiative, and we were speaking yesterday about it in the self meeting that we had, about early neutral and evaluation of a dispute. Here what happens is a neutral third party, often the experts in the field of disputes, will evaluate the strengths and weaknesses of the case of both the sides early in the process. And then the evaluator will provide a non-binding assessment which helps the parties to understand the likely outcome of the litigation or the arbitration. Now, this is likely to encourage parties to negotiate based on realistic expectations. It is likely to reduce unnecessary litigations by providing clarity early on, and it can actually be used for commercial disputes, for IPR disputes, as well as for construction disputes or all kinds of disputes for that matter. The other element that is important is online dispute facilitation. I spoke about online dispute resolution, but there are also ODF mechanisms which are now being brought into place, which is a subset of the online dispute resolution, and it also helps leverage the technology to assist in resolving disputes. So ODF focuses on facilitating the resolution through digital means, often involving negotiation, mediation, and arbitration, which is conducted online. This expansion of ODF into new areas like e-commerce, such as employment disputes, small claims, are going to be hugely beneficial and cost effective as well. The other element that I think is important to talk about is peer mediation, a process where the trained mediators who are peers of the disputing parties, like students or co-workers, who facilitate this kind of a resolution. If we are able to build in mechanisms like this, it will build trust and understanding because you have a shared experience in that sense. You will be able to promote a very collaborative and inclusive kind of a resolution process, and it is likely to be used more in workforces where there are smaller kinds of disputes emerging. The other element which also could probably be relevant in future is a neutral fact-finding exercise, where again it is a neutral expert who investigates and verifies the facts related to a dispute and provides a non-binding report to the parties, which can also be used for negotiation as well as for arbitration. It can bring about a certain amount of clarity and objectivity in complex disputes, and it will reduce contentions by establishing agreed upon facts. So I think there are many such kinds of emerging, solutions that we can look at for future of dispute resolution, and probably make a shift from the kind of traditional dispute resolution mechanisms that we have been talking about, and admittedly which has failed, both litigation and arbitration. So far as litigation is concerned, I think the most important aspect that has to be introduced if litigation has to work, one is to increase the number of judges, and second is to introduce the case management system. I think all over the world, if litigation can be successful, it is because of these very important elements. And third, the responsibility and onus also lies on us as lawyers, because all of you are also lawyers. Please remember, we have to reduce the number of adjournments that we take, be prepared for a matter when it is listed for arguments, and ensure that we take the least amount of time when it comes to, arguments of those matters. So I think these are some of the important aspects. Just to touch upon it, there is one very important aspect that also need to be talked about, which I think somebody from Alliance University spoke about, is capacity building in education. I think that's a very important element. Unless and until we are able to build capacity at all levels, right from the level of student to the level of practitioners to the level of judges, that is going to be a real game changer. If we have to change the manner in which dispute resolution is being done in India, we'll have to work on the capacity building at all levels. So that is some of my thoughts. Thank you so much for being such a patient listener, and I'm happy to be here.